Good morning, my name is Lisandra Jude, and today, October 29, 21, I'm going to be presenting the case of the state of McCall versus U.S. on the unconstitutionality of Florida's cap on non-economic damages in medical malpractice wrongful death cases. This case was filed in the District Court, United States District Court, Northern District of Florida, and then was sent to the Florida Supreme Court, challenging Florida law violating the Constitution of the United States of America. The plaintiffs of the legal parties of the case are the plaintiffs, the state of Michelle Yvette McCall, with family members Margarita McCall, Heather McCall, and Jason Wally, which are the husbands and the parents. The defendant is the United States of America. So the sad events of this case started on June 2005 when the patient decided to receive prenatal care and delivery service with the United States Air Force Clinic. There was no previous condition reported on behalf of Mrs. McCall Health until the last trimester. The test results from February 21, 2006 revealed that Ms. McCall's blood pressure was high and that she was suffering from preeclampsia. So the doctors of the Air Force Clinic decided to do an immediate induced labor. So due to the slow and weak contractions, the doctor from Air Force Clinic called Dr. Arbal to perform a cesarean section on Ms. McCall. So, however, Dr. Arbal was performing another surgery and he wasn't available. The Air Force family practice doctor did not call another obstetrician, so they decided to wait. On February 22nd, 2006, Dr. Arbal arrived to the hospital to perform the C-section. However, the contractions of Ms. McCall started again, and they decided to allow Ms. McCall to deliver naturally. The obstetrician left the hospital again. So on February 23, 2006 at 1:25 a.m., Ms. McCall delivered a healthy boy. And 2 hours after, 35 minutes after, by 2 a.m., the Air Force doctor realized that the placenta did not deliver how it should be. So they without success, they tried to extract it manually. As a result, Dr. Arbal, the obstetrician, was called again for assistance. And during this period of time, the blood pressure readings of the patient was 125 with 80 at 2:31 a.m., 94.43, 2:34 a.m., and at 2:39, the blood pressure was around 86 with 36, and it remained in this range for the next 2.5 hours. At 2:35 a.m., Dr. Arbal arrived for assistance and extract the placenta for around 5 minutes. At 3:50 a.m., Dr. Arbal ordered the complete blood count, and it depends on the result, a transfusion of RBCs if it was needed. 5 a.m., over an hour after, Dr. Arbal asked for the test. A nurse tried to attempt to draw the blood, and he found the patient unresponsive, and an emergency code was issued. And Ms. McCall was into shock and cardiac arrest, went into shock and cardiac arrest as a result of severe blood loss. Ms. McCall never regained consciousness, and it was incubated at 5:19 a.m., and she was removed from life support on February 27, 2006. Legal action was taken by the petitioners. They filed economic and non-economic damages. Under the federal tort claims, the federal government acts as a self-insurer and is liable in case of damages to property, personal injury, or death caused by negligence or wrongful act or omission of a government employee while acting within the scope of his or her office or employment. So according to the U.S. government publishing office, they share the order and the final judgment of the case. And in there, Nurse Acosta admitted not reporting the real condition of the patient to the physician. According to the medical records, the recorded vital signs of Mr. McCall by 4 a.m. were blood pressure levels of 7135, and her heart rate was up to 131 beats per minute. So Dr. Arbol acknowledged he should have been aware of the vital signs of blood loss of the patient, and that he also acknowledged that the report of the nurse of being stable was inconsistent with patient's vital signs readings. According to Dr. Molding, which was the assigned expert in the case on nursing care, their failure to recognize these risks led to their underestimation of Michelle's blood loss. Due to the clear medical staff negligence, the district court found the United States liable for the death of Michelle McCall. The economic damages totaled $980,462, and the non-economic damages or non-financial losses totaled $2 million. However, under the Florida statute section 766.11a, Florida have limitations of non-economic damages for negligence of practitioners, which states that the negligence results in a permanent vegetative state or death. The total non-economic damages recoverable from all practitioners, regardless of the number of claimants under this paragraph, shall not exceed 1 million. By saying this, the non-economic damages recovery was limited to just 1 million, and it was signed by the George Casey Rogers. Of course, the family placed motion and petitions. The motion was under advisement on November 17, 2008, according to the court dockets, and a notice of constitutional challenge to the state status was filed on May 19, 2009. In the motions, the petitioners states that the statutory cap on non-economic damages in Florida violates the equal clause of the 14th Amendment, which says at the same time it violates the clause of the 5th Amendment of the U.S. Constitution. The 14th Amendment says that no state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So basically, it protects every citizen privilege and rights to be deprived from the state, and all citizens should be treated equally, and they should be equal in every aspect of the law. So by violate the 5th Amendment, when it violates the 5th Amendment, it states that every citizen should, it protects the citizens of being abused by governments. So the motion of the petitioner's motion was denied on September 30, 2009, and they say that the challenging party, the plaintiff, did not prove beyond a reasonable doubt statutory caps were unconstitutional. So they say that every malpractice case, the family are treated equally and the caps are reasonable. So the family sent the appeal to the Florida Supreme Court. The plaintiffs in the Florida plaintiffs in the Florida Supreme Court, a brief summary sent by the American Bar Association and signed by Herman Rusmano, which is the consul. It was sent on August 4, 2011, and they defended the state of McCall by doing a research, collecting and submitting 3 decades of cases affected by imposed limiting caps and therefore affecting injured persons to seek redress in court. On behalf of the defendant, there was brief summary signed by the U.S. Chamber, the Florida College of Emergency Physicians, and the Florida Orthopedic Societies. They state that they need the statutory caps, they need limitations, and they say they are important for Florida healthcare system to avoid high malpractice insurance premiums that could lead to physicians leaving Florida or refusing to perform high-risk procedures, and even having physicians retire earlier, or it affects access of Floridians to specialists if we don't have these limitation caps. So on May 13, 2014, or May 13, yes, the Supreme Court alleged that limiting non-economic damages in medical negligence action, in fact, was unconstitutional. So they agreed that the statutory cap did not serve its purpose. It was not rational, and did not resolve the alleged medical malpractice causes. They failed to prove that by putting these limitations, the rates of the insurance premiums in malpractice didn't go down as much, or the rates of malpractice suits went down that much either. It wasn't affected by the limitations. So the state of McCall recovered the cap amount of non-economic damages, and actually now is used as a precedent in cap medical malpractice cases. Florida legislators will need to prove there is a crisis to enact these caps. Otherwise, non-economic damages should be evaluated per claimant and not per claim, to respect every citizen's rights and privilege granted by the Constitution of the United States of America. Reviewing both parts of the ethical dilemma rises because we're setting a price to our mental and emotional pain and suffering after being adversely affected by medical negligence. And truly, there's not a number that can erase that pain, and it's never going to be enough for us as being. So it's just by granting the correct compensation, it gives us a sense of justice, and someone was held accountable for what happened. Thank you.